I'll tell them.
Is the mic on? Start really loud like God.
Oh, they said, okay, I'm sorry.
Oh, they mess up everything. They come in here like they own the place. We charging them or we just letting them use it?
Good morning,
Good morning. City, they move stuff around.
and welcome to the Wednesday, July 9th, 2025 informal meeting of the Board of Education. This is an information meeting only. We do not take any votes. I'm glad that you're watching, if you're watching, and we will get started with a presentation from Mr. Dennison.
All right, so I'm very excited to be here before you. We had a bounty of legal goodies to go through from the past year. So I'm doing this PDF style. I'm sorry for that, it's not on the PowerPoint, so you'll have to deal with a little information on the side, but the slides are big enough, hopefully. So this is your legal update. All right, so what we're going to do, we had a Supreme Court of the United States issued a number of decisions, within the last month, and they had a pretty significant year when it comes to things that are relevant for schools. So we're going to touch on some of those cases. And then we had a really big year from the legislature. It seems to be every other year is school year at the legislature, and this was our every other year. So we have a lot to work through from the state. And I'm going to try to just break out some key trends that we're talking about, and some tasks, like where's the action, where are the things that have to be done based on all these legal changes, so you can see what's going to be coming your way on a policy side and what we're going to be doing on a district side to deal with all these changes. All right, so we're going to put our Supreme Court cases into 4 buckets. We're going to have our parent rights bucket, our government liability bucket, religious entanglement and freedom bucket, and a separation of powers bucket. So as we think about the Supreme Court, we really kind of right now have sort of three groups of 3 in terms of the 9 that make up the Supreme Court. We have the more liberal wing of the court, which is right now, there's 3 of them, so they don't have the power. So there's a lot of dissenting opinions and things of that nature, but you can't really simplify what the Supreme Court has done and put everybody in simple boxes with these opinions when you really look at it. But from a big trend standpoint, you have 3 that on the liberal side of things that don't really have the power and the votes, but they are, a lot of the dissents are just saying, what are we doing here? This is really bad. This is going to affect the rule of law, et cetera, especially with a recent case about the Trump versus CASA case, which we'll talk about. So then we have our 3 sort of ideologues, so which they each have their own different sort of versions of either originalism or something else, but they're not quite as pragmatic in their approach to the cases. They have an ideological view of sort of what a court should be doing and how it should be interpreting the law, and that really drives their decisions. And so lots of times they'll be issuing things that may sort of almost kind of blow things up and be disruptive in terms of what government has done because of their approach to interpreting things. But there's really 3 of those, and then I'm going to put these other 3 sort of, this is Barrett, Kavanaugh, and Roberts. They kind of hold the cards right now. I mean, although they are seen as conservative justices, they're pragmatic and they're formalists, so they're trying to make the institution work and not necessarily blow everything up. And so, but their opinions are really carrying the day in a lot of situations, and they're basically trying to find a way to justify it based on past decisions, and they tend not to go over the edge in terms of, you say, oh, if we have this case, it's going to take us on this slippery slope. They seem to be less concerned about those slopes and think that they can navigate away from sort of absurd results. So the big parental rights case, so we remember from last year, we talked about the Harvard case a lot, and we said this case is going to have a significant impact on us as a district, and it did. And I would say that the the case that's out there that has the biggest, is going to have the biggest impact on school districts across the country is this Mahmoud v. Taylor case. It is from Montgomery County, Maryland, and this is a case about the books, the LGBT plus books that were incorporated into the educational system, and initially having an opt-out right for parents, and then getting rid of the opt-out right, and then parents different religious persuasions gathering together. I think 1,000 parents filing a petition objecting to this process and saying that they couldn't opt out. We had some dramatic board meetings about, hey, you can go to private school, et cetera, et cetera. Well, we have our opinion from this case, and the majority of the court sided with the parents on this case in terms of looking at this and saying, you can do a better job, Montgomery County, of accommodating the religious beliefs of the families here, and what you've referred to as the administrative burdens you're going to face, like too many people opting out or students being stigmatized because they are opting out, these sorts of things, that's not carrying the day for us vis-a-vis these religious rights. And we're going to look at this from a strict scrutiny standpoint. And plus, you did opt-outs before, so why aren't you doing them now, et cetera. So this is in the context of, books for, younger children, because that's people choose sort of the most dramatic thing that they think they can, people choose cases based on facts, especially that go to the Supreme Court. So I think part of that scenario made it particularly, driving emotions, getting people to say, hey, why are people putting this forward and requiring students to be essentially indoctrinated in many people's view to these particular views contra to the parents. So where does this leave us with evolution? Where does this leave us with all sorts of other things? I mean, one of the things they give as an example in this case is, hey, they told parents, if two men want to get married, they can, which of course the law is if two men want to get married, they can. So if that's not a proper thing to tell students, that's like one of these little dangling things. It's like, okay, well, a lot of the other things you can see is more indoctrination, but where does that line end and begin? We already had the Parents' Bill of Rights in Georgia, of course, and so there are parallel tracks with the Parents' Bill of Rights and this, and recognizing the rights to parents, specifically in Georgia. So how this will play out, you would expect to have more challenges from parents about whatever we have. Of course, we already have opt-outs when it comes to health issues and things like that. There's required opt-outs, and then, like I said, we have the Parents' Bill of Rights. But where this will go and to what extent, and we already had the book challenge law, so someone could challenge. We already had a mechanism for that in Georgia where that could be done. So I think we were sort of already in this from a state standpoint. But what this does is to say, if people were going to challenge the Georgia laws using federal constitutional arguments, they're going to have a lot harder time doing that right now. Those are a lot more solid. So then we have the Scarametti case. That was the medical transitioning case for children under 18 in Tennessee, and that one went the opposite way. So it's hard to just pin things down and say, oh, this court's all about parents' rights. It was about parents' rights in Mahmoud, but it wasn't really about parent rights in its equal protection analysis in the Scarametti case, which is a complicated case, and we don't have time to just totally unpack that one. But so that's a big case. So good news, we did have some good news. We had that Bright Loper case, which felt like the sky was falling in terms of anything that anyone would do administratively is going to be subject to challenge and could be, like I said, that's the laser shooting out of the spaceship with Gorsuch and others in it. But that Bright Loper laser hasn't blown up everything to the extent we maybe thought it would. As we look at these separation of power cases and we kind of process them, it's one of those things where I think that middle three is saying we're not taking this to absurd results. And a good news for us in terms of not going there is in the FCC Consumers Research case. That's the E-rate case. It was 6-3 decision to say that E-rate is constitutional. So we continue to get those E-rate funds under that, which is significant because it's millions of dollars just to us, I think, over time. So that's a big sort of win for public schools that maybe people did not quite pick up on or notice. And I will say this, and I shared this with Dr. Watts just for sort of giggles and fun, I guess, or maybe to benefit the public somehow, some way. I put a bunch of podcasts up there it's called SCOTUS Intelligence, and it basically just uses Notebook LM to, you just put the opinion in there, and these two fake people make a podcast of it, and it's actually pretty darn good. So we've got 21 cases right there, up there. It's about 15 to 20 minutes each. So if you want to listen to these Supreme Court cases, it's SCOTUS Intelligence. So I didn't do it on, my school board time. I just put it up there. So you're free to listen to these if you want to hear what the robots say. But they're actually really accurate with a single item breaking down one opinion. It's effective. So here, government liability. This is a trend. We keep facing sort of more and more exposure is really the trend. It's not a good trend when it comes to liability. We had the Osseo area schools. I don't think this is a huge one for us. This is the context of a student with disabilities where they did not continue to accommodate that student and allow that student to attend evening classes at a new school they went to because the student had epilepsy, didn't do well in the mornings. And when they moved to Minnesota, the district did not accommodate and give them an alternative time. That was just the particular facts of that case, and we have to kind of look at the lens of the facts of that case in terms of what we're doing in accommodation, because that's the backstory. The major holding of the case is all about the standard of liability for both getting an injunction against you and maybe potential damages under Title II of the ADA and Section 504. And there was a special exception for school districts where we could say you had to show bad faith or gross misjudgment. That's not the standard anymore. Now the standard is deliberate indifference. And this was a split in the circuit. Some were having this deliberate indifference standard. We still should be able to prove that we're not deliberately indifferent about accommodating our students with disabilities. So I don't view this as like a huge avalanche of exposure, but it does officially change that standard of proof in terms of getting to whatever those potential damages could be under Title II of the ADA and Section 504. There's an argument that that whole liability structure itself could all go away, or the standard could be greatly changed, but that was not before the court. The justices signaled, hey, we might blow this whole thing up or change it completely, but you haven't raised that before us. So we might get back to that later. So there's still some bit of uncertainty about what that standard could be. It's just not going to be a special standard for schools. The Ames case is I'm sure Sean's super familiar with this one. It's hot in the HR world, but this is, the no reverse discrimination, or that reverse discrimination claims don't have a different standard than regular discrimination. So whether you should even use the term reverse discrimination now is called into question with the Ames case. That was employee that said, you're discriminating against me because I'm not a homosexual. Homosexuals are getting the jobs and I'm not. And then they said, well, to prove that claim, you have to do additional things and than a typical claimant for discrimination would do. The Supreme Court said, no, you're going to treat everybody the same. This lines up with Harvard that we've already been through this drill. They're going to look at discrimination through that same lens. This case also shows us that there's this sense that with Title IX and everything that's going on with the White House in terms of what sex is under Title IX, that the expansive version of what sex is under Title VII that was established under the Bostock decision is still there for Title VII. So you can't say because there's executive orders about Title IX, we can limit what is deemed sexual discrimination. Bostock is still the law for Title VII. So we still are not, are limited in terms of that piece of, in terms of sex discrimination. It's not just biology under Title VII. And then Williams versus Reed, this is just one that, lots of times, admittedly, government lawyers, we want to defend, all lawyers want to defend our clients however they can. And this was a case where, it was like, well, you can't get to this claim until you've shown you've exhausted administrative remedies, but it was sort of impossible to exhaust the administrative remedies. And basically the court saying, when it's impossible to exhaust the remedies, you can't say you lose because you haven't exhausted remedies. It's a general principle of like, you just can't be too clever about using that defense. They actually have to have a real opportunity to access those remedies. And we've had similar cases like that before. And then the one at the bottom that's not a Supreme Court case with a little plus on it, that is our Georgia Court of Appeals case, Wilson versus Anderson. The Supreme Court of Georgia decided not to review that case. A lot of folks in the school world were pushing, the government world were pushing for, writing briefs and such so that the Supreme Court would take that case on, because it is a dangerous case in terms of expanding liability, particularly, we're talking about official immunity of employees, whether they're doing ministerial duties or not. This whole thing about the shall and the shoulds and the wills and the won'ts and mays. So that when you have, in this particular context, it's always bad facts make decisions that are troublesome. This is a situation where there was information about bullying going on, and there was supposed to be an investigation according to the policy. They couldn't prove whether this investigation had happened or not. Or at least there's a fact dispute as to whether the investigation that was supposed to have been conducted took place. And then the student, who I think was a 14-year-old girl or something, got stabbed, or maybe she got stabbed 14 times. She got stabbed a lot of times, including the face, and it just was by the people that were suspected of bullying. And basically the court said, no, you can't, this is something that looks like you had to do and you didn't do it, so I'm keeping this in play that could go to, to a jury on this case. So when we think about all the things, and we're going to look at what the Georgia legislature has done, this really raises the stakes for compliance with safety-based legal requirements, which now we are facing a myriad of them, of fresh ones, and they're already out there. So when you have the context of bullying, and we have this cyberbullying law that was passed last year, now we've got to kind of roll it out and implement it. We have Senate Bill 268, which is all about everybody getting the right information about who's potentially dangerous and who has a record and who has issues, and making sure everybody has that information. So you can imagine people are going to be looking for situations where they can say, oh, look, you didn't do X, you didn't do Y, and then now this person has been stabbed 14 times, or this person got beat up after school or whatever, and they're going to be looking to bring, these claims anytime something like that happens, and they're going to be pointing to this Wilson v. Anderson case. Now, it's a Court of Appeals case. It's funny, like a hyper-technical thing for Georgia lawyers is that you can't really rely on these Court of Appeals cases as just clear precedent as you would a Supreme Court case. So it's not a Georgia Supreme Court case. So we're going to see what happens when the next few sovereign immunity and official immunity cases come up through the Court of Appeals and the Supreme Court. Is this going to be rolled back? Is it going to be sort of spread around? Is it going to be expanded? We don't know. But this is pushing it out to the edge of liability in a way that's pretty aggressive in terms of this particular case. So it's a concerning case in terms of, potential exposure of school districts. Don't need to go through all these. You can listen to them on the podcast if you want to, but they don't have super big impact on us. So this court, lots of times the court, joins in together with 9-0 decisions. That Osseo case, the case about deliberate indifference standard, that was a 9-0 decision by the court. This was also a 9-0 decision, this Catholic Charities Wisconsin case, and it was basically Wisconsin was saying, hey, you can't be a charity and run a soup kitchen if you're a religious organization unless you incorporate more religion into your service. Like you have to be like blessing the food and doing other things that are more overtly Christian in terms of practices if you want to benefit for this particular Wisconsin provision for, tax exemption, whatever, I forget what it was. It was like an employee provision. And they said, no, you can't, we're not going to get into the weeds of what really is a religious activity or not. Catholics, their religious activity can just be, they just want to help people eat. That's something that Jesus told them to do. So it's kind of okay to just do that without doing all the other things, and you're still doing a religious activity. But let's not let the bureaucrats in Wisconsin parse that one out and figure it out. So that was a 9-0 decision there. The one that could have been a lot more interesting was that Oklahoma charter school case, which is really about how Christian a charter school could be. And we did not get an answer on that case because Justice Barrett, who was at Notre Dame Law School, and she was in the sort of think tank advocacy group connected with that advocacy group that decided to advocate on behalf of this charter school. So she recused herself from the case. So we ended up with a 4-4 And it just got sent back, like nothing happened. So we don't really know what the answer to that question is. We know we have a 4-4 split. We're pretty sure as to where where Justice Barrett would come down on this if she was not conflicted out, and whether there'll be a case where she's not conflicted out that will come to her or not, remains to be seen. So this is out of order. I said separation of powers earlier, and then the slides were out of order, so I apologize. So we're back to separation of powers, and this is this universal injunction thing. So if you might remember a year ago, and I know I'm fire hosing y'all, so I'm sorry for that. But a year ago, we were talking about Title IX, right? And we had the Biden administration, Title IX stuff was going to be operationalized in terms of the sexual harassment protocol process. And then we were waiting to see if that shoe dropped. It dropped for about 3 days until there was a court decision that said, no, it's not going to be. And it wasn't it wasn't initially a Georgia case. First it came out of Oklahoma. Then we had something and eventually got to the 11th Circuit. But you had courts all over the country issuing, these injunctions saying, no, you can't do that. And there was a similar one with Section 504 that, people were asking for universal injunctions. So what does that mean? That means I just go down to whatever district court I want to, federal district court, go down to the Southern District of Georgia, to Wright Square or wherever they are right now because it's under construction, right? And you go to that judge and you say, I want you to tell, the administration to stop doing this everywhere in Washington, whatever, anywhere that I have some kind of, so, that was what happened in this case, because it was a bigger issue, is birthright citizenship. So they could have dealt with birthright citizenship. They did not deal with that. They just used this as an opportunity to sort of rein in these district courts and say, when Biden was in power, this thing kind of got out of control. And now that Trump's in power, it's out of control on the other side. So we are going to roll back this practice in terms of. But then they left a lot of other options as to what could be done. You could bring an action under the Administrative Procedure Act against the agency just about anywhere, not necessarily against Donald Trump. What's the ultimate difference there? They also pointed to the class actions that could be taken that could have a wide jurisdictional impact. So they basically said there's other tools for having results that can affect things nationwide, but we're tired of these district courts sort of overstepping their bounds and issuing universal injunctions against the federal government here, there, and everywhere. So, but the tools are still there. So those tools will come up, and then they'll also be tested as well. But I do think we're seeing the court. There used to be something called the shadow docket, or these different dockets where most things are on this slow track, and it's this life cycle that's going to take a while to get to the Supreme Court. But this court is recognizing, it needs to step in faster because agency action, executive orders, things that are having a wide impact across the country are impacting rights, are coming fast and furious, and they need to be addressed more quickly and by somebody that has the final say on the matter. So you're seeing the court, and I think they just yesterday, right, we had a decision after the court's term had closed about the Trump's ability to terminate employees. So you think that they're done, it's summertime, they just issued their raft of opinions, boom, they've issued another one. So they're coming into this space and being a lot more active and quick in terms of giving the Supreme Court guidance. So, we're going to have less of this situation where district courts are in between figuring things out. You're likely to see these things either go these other paths or get right to the Supreme Court. Anyway, that's a lot. So that's the Supreme Court wrap up. I'm going to try to give at least some time for questions, but if you want questions now while that stuff is fresh in your mind, I can do my best to try to answer them, or we can keep on rolling.
Yes.
And so did you say you were going to talk about the Georgia case?
Exactly.
Okay, I'll hold my question until then.
And so with that, I'm just going to keep on rolling. So you already heard a lot about executive orders when your board training happened. So I just have a couple of slides here. This is just general trends with what's happening with executive orders. Not going to spend a lot of time unpacking those, but we'll talk about something about AI here briefly, but let's get right to what happened with the Gold Dome. We have the buckets here: safety and student records, attendance and well-being, technology, sex and gender, sounds like Jeopardy, right? Charter schools and home study, HR and benefits, campaign finance, and miscellaneous. Potent potables for 200. All right, so this is just a mega bill, this 268. It's just like you can't even begin to read it. Thank goodness for GSBA and others that have like taken the time to sort of unpack this thing. And AI actually, I tried to see if AI could help me with this bill, and it just could not. It was not able to give me anything that was worth a darn, unlike the Supreme Court opinions. But there's so much to this bill. But it's driven by safety. So we had the incident in Appalachia. So then you take this sort of blue sky legislative approach, like what are all the things we can do to make our schools safer that we can think of, that we can roll out, that are maybe doable, and they put it all in this omnibus legislation. So there's a lot of things that have to do with when the students are enrolled and what's disclosed between different schools and how fast that has to happen. And then ways of resolving disputes when it doesn't happen fast enough. This isn't going to require a lot of policy work from y'all, but it's going to take a lot of work from team members. So, we're already meeting the SIS team, the counselors, Ms. McGuire, Ms. DiTomaso. We're forming a group. We're working through those things to figure out what are all the things we need to do operationally to make sure we're going to comply with this. But it's nothing that's really screaming right now in terms of we've got to get this thing before you for a policy adjustment right now. We may change our minds, but it's really driven about operationally what we're doing. But it's going to roll into this, we have the juvenile court that works with us in terms of the truancy protocol and that whole piece, and we have this massive agreement. And we're going to basically have to tell them, they meet at the end of August, we're going to have to start sharing with them what the implications are of this to that whole protocol and how to integrate all that there, because this isn't what they do every day, but they're sort of in charge of that protocol. So we're going to need to partner with them to get that up to speed. And of course, you guys have just been through, the attendance piece, and we'll just touch on that briefly. It's going to be before you for a second reader today. So we feel good about where we are, but we may need some additional tweaks down the road. But we're waiting to decide whether we need to do that. So records transfer, there's this whole thing about critical records. So we're defining records in different ways. The statute defines what critical records are, which we have to get right away to schools. And it really feels like the records you want the school to have to say, is this child a safety risk potentially? And so you have two tracks. One, the parent has to talk about all the criminal Class A, Class B felonies. They have that requirement. They got to sign off on that. We already had something similar to that, but now it's been codified. We might need to change our processes a little bit to fit that. And then this piece about the critical records. And we've got to give the critical records for the past 24 months to other schools quickly so they can make those decisions on enrollment. And we've got to expect them to give it to us quickly so we can make those decisions. And if you don't have those records, then you have this new version of provisional enrollment. We already had provisional enrollment that was based on you couldn't really prove academically how you were doing, but now we have to have a provisional enrollment about maybe you're not safe. Of course, we have the option to decide what we do there. One of the options is having a remote learning period during that window of time before you've officially cleared the person. But on the other hand, if they're coming from a juvenile situation or Department of Health and Human Services situation, DFAC situation, then you have to do immediate enrollment. But I guess the presumption is that those students have particular issues and you should account for them because they're coming from that place, whereas others you may not know. So it's not about that you're not serving the students because they present a risk. It's about knowing what you need to know to keep everyone safe, making sure teachers are aware, everyone has that information. So you fast track maybe some students that because of their past, you would say we need to be aware and alerted, and they're also supposed to give us their records in 5 days, and if they don't, we have a way of fighting with them administratively for their records. And apparently RISA people are going to start getting involved in battles. But lots of times when these procedures get set up, they almost never happen. So we have a lot of procedures and protocols. They're out there if you have to do them, but oftentimes everybody can say, yeah, that's the law. Let's start following the law, and we'll figure out how to do it together. So one little bonus there was a political prohibition on accessing directory information. And we've already, as a matter of practice, we always said, if you're trying to get directory information and it feels like it's for like a political list or something, we're not giving it to you. We've, just because we have control sort of over directory information when we say it's a good reason to give it out. But we may need to, there may be a policy change just to officially account for that. So that could be coming before you at some point in time. And we're going to follow the law in the meantime. But you could see that come to you in the next few months just to clean up directory information to fit with the, that political exception to the use of directory information. So you said like teachers are supposed to know what's going on. We've got to report prohibited acts. Campus police has a lot of heavy lifts on this. I mean, and the good thing is because campus police has been moving forward with their emergency response systems and with, you know, different pieces of the puzzle for implementation, regardless of the law, they're actually they're really on track to meet a lot of these requirements. But there are some things that we're going to have to lean on campus police for. And then we also have to have MOUs with all the different police departments now. Of course, we know we have so many in Chatham County, so you're going to see these MOUs coming your way. And, you know, I was just, you know, Deputy Chief Rodriguez just raised to me that there's something else where GCIC, which is a criminal background check, wants everyone to be fingerprinted if they're using another department's information or sharing it about background, and they have to do it for each department separately, which would mean we would have to like do the same background fingerprint check 8 times. I can't imagine that's actually what they want us to do. But these are the kind of things that make the MOU more complicated, because are you going to roll this in? And then you could have pushback and disagreements as to what should be in there. But we've been called to do this to get straight on the relationships between the other police departments in our jurisdiction. And they have to do behavioral threat assessments. That is interesting. And that goes into this situation of like, what information does campus police get in their role? What do they get as FERPA? What do they get to meet certain legislative requirements? And because the state recognizes that a lot of this information share is going to be very complicated, they're also forming a special committee that's going to tell us what an educational record is. Of course, we always have had the definition in FERPA, but they're going to tell us that, and then they're going to tell us a lot about how things can work with law enforcement. And that's supposed to come out, I guess, if they're on schedule at the beginning of next year. So we can wait for that guidance to see how to do that. But of course, we're supposed to issue these MOUs before we have the guidance on how that works, which makes it somewhat challenging. But we can go back and amend our MOUs after the fact once we get the guidance that tells us that our MOU is not exactly right, or amend it just in order to adjust as appropriate. So you might get those MOUs a second time as we try to meet that deadline, and then we get new guidance that causes us to revise them. These PBS and RTI requirements, that could be a burden and a lift. We've got team members looking at that in terms of if you have climate ratings of 1 and 2, you're going to have to do all these. I mean, we integrate PBIS really into all schools anyway to a certain level, and the RTIs, but this sort of universal, everyone gets PBIS if you fall into certain categories of a school. That will be something we have to make sure we work through that. And then they sensed that there were issues about, well, what can we really do about what happens on a school bus, and what can we really do about threats that are made off campus because of the jurisdictional issue. So we have a couple of add-ons there, and those could find themselves into JD eventually, coming to a policy situation near you. So that's criminal incident reporting. Like I said, these are the ones on the law enforcement. Sorry, I got ahead of myself, but campus police is aware of these. They're moving forward, but it's a lot. And to the point that Board Member Bringman always brings up, a lot of the times these things say, you're going to have to figure out a way to pay for this, right? Without really saying it. So you have, whatever, these are unfunded mandates, but, sometimes the money comes in different ways. Sometimes it comes after the fact. There has been a lot of safety grants. So I think they're saying, hey, we've given you a lot of money. But, obviously to implement all these things cost money. So attendance and well-being, we have this new definition of chronic absenteeism. I know we've been working through the truancy-based definition. Now we have chronic absenteeism, which is a longer window of time. We have gone to the 5-day window because it's officially the criminal provision. I see everybody. Yes, I know. Let's just take a deep breath. Okay. We have withdrawal requirements that is going to be tricky for us because they have new legislation about what is officially withdrawal, and it's different from what the regulation currently says. So we're going to have to figure out, is there going to be new guidance? Does the 10-day consecutive still apply? Does it have to be 30 days? Do the conditions of the 30-day have to apply to the 10 days? Are they just going to get rid of the other one? But I think this is a lot about this idea of it's not for the public schools to just simply say, this child hasn't been coming to school, not our problem anymore. It makes it harder. The new withdrawal, it extends it out and brings in certain conditions to sort of make, your status with the school that you've last attended stickier in a way. And I would think that they will be going with the new withdrawal in the statute versus the one in the rule, but it's still there on the books right now, and nobody's totally sure. There's a position called Student Advocacy Specialist. If it in fact gets funded, which it hopefully would, we could get 2 of these. You can check out and see what these folks do, but they would be there to advocate for students and do certain responsibilities. For those of you at the GSBA session, there were 2 slides on the things they can do, or 3, I think. But we're going to process that. And suicide awareness training is picking up in terms of those requirements. We always seem every year to have more training requirements that get added, and the PBS piece is going to have a training piece that's separate from the suicide training piece for the schools that qualify for the PBIS. So once again, just more and more trainings that get rolled out. We have anonymous reporting scripts. We have youth violence prevention clubs that have to be formed at all schools. What if people don't want to be in these clubs? I don't know, but we're going to have to mobilize all these clubs. So the sex and gender, they're calling it the Riley-Gaines Act, and this doesn't change things drastically for us because we were already subject to the high school, sports GHSA. They had their own rules, and those rules really aren't that different than what was enacted here in terms of athletics, which is basically you're supposed to play based on your biological sex. If your biological sex is female, then you'd be female, male, male. And then if you are a female that wants to play on a male team, okay. If you're a male that wants to play on a female only, no. So just all the male volleyball players are still just sort of left out in the cold unless they develop, their own male volleyball programs or whatever. But that's basically where we are. It's not that different than where we were. But then there's all these other requirements about designating every locker room and space. So facilities has their marching orders of designating all these spaces, and there's different rules of yes, the custodian can still go into the girls' bathroom. There's a special exception for the male custodian to clean it, but there's all these different things. It doesn't totally go into the overnight away trip thing, but it kind of does. So it's kind of hard to know exactly where it's coming down because it talks about sleeping quarters, but it seems to be talking about sleeping quarters that the school might own as opposed to just some hotel in Washington, D.C. But they say, the way you accommodate it is you just give somebody their own room. Well, okay. So that's kind of something we'd already been doing, honestly, in terms of our approach there. So talk about liability, it gives people a new way to sue for damages. So there is a special carve out of sovereign immunity sort of here, I guess, if it's constitutional, to sue for not doing what you're supposed to do under the Riley-Gaines Act. So we have another potential add-on to liability. And there's also a grievance procedure that we're going to have to add to policy. Our JCER is already pretty stacked full of things, but we're going to need to add this one in there as well because it has its own special grievance procedure. And if we do it if somebody raises it before we put it in our policy, we'll still follow the law and, allow for the procedure. So we've got the Distraction-Free Education Act. This is probably, I think, your heaviest lift from a policy standpoint. So you've got to have a policy by January 1. Of course, you only have to not allow people to have cell phones by July 1. So I don't know if you have a policy that says we'll get as of July 1, I think, the way I read it, you can, otherwise it would be absurd. But the policy has to be finalized, and there's various components in that policy, like how are you going to handle, IDA 504 accommodations? What's the discipline going to be? So that's going to have to be added to the discipline handbook. What's the process for telling community about, so it's a lift on communications as to how it's going to be shared, what it's going to be. Of course, they'd be doing that anyway, but, and you can still have a limitation for 9th through 10th if you want to, or you can vary it, but it's very clear that, bell to bell, there's going to be certain requirements that you can't have them. You've got to have the places where you can keep the equipment, and I know that team members have been working on that, but it's just, that policy is there for y'all to figure out, what it's going to look like. And of course, you're kind of doing it while you're waiting for guidance once again, so you could amend that policy, if additional guidance comes out that's different to that policy. And you could also start it as soon as you wanted to, right? I mean, it's nothing is saying you can't start earlier if you didn't want to roll it out earlier. Of course, from an operational standpoint, rolling it out at the beginning of the school year makes a lot of sense in terms of, how disruptive a change like this can be to the status quo. Now, we've got the Protecting Georgia's Children from Social Media. And like I said, this goes into that whole liability thing for bullying, because this is about bullying, and we have to have our protocol, and then we share this what our approach is going to be. It's that's going to be coming up. We have to have that out by October, and then on to the state by October 15th. And I know that folks have been working on that particular piece. So that's the acceptable use policy, which you already have, but whether we're going to modify it in light of the act. And then they're going to give us guidelines by December 1st to tell us what we're supposed to be doing. And that may have policy implications for us based on what that guidance is. And then, but they're supposed to have a model policy by the first of the year, 1 month later, 1/1/2026, a model policy. So then that will be the policy that we presumably will need to adopt. And then by April of this school year, they're going to have compliance standards for technology, which it's already been a real challenge for our team to be able to say, okay, let's see if this is disability accessible, technology. Let's see if it is safe and secure in terms of exposure to risk. Let's see, now you've got AI with its own complications. So now we're going to have this new guidance to say, do all this with everything. And so many of our contracts all have this component of technology. And who is really out there, that has the capacity to do all the things that people want to say is best practices in terms of at the school level? It would be really nice if we had a higher level approval process, that where everything was getting approved at the state level and we weren't left to do it ourselves if they really want to. So that would be a pitch I would have in terms of a master approval process instead of asking every district in Georgia to do all of this work. The same could also apply to disability and accessibility, standards. Of course, the standards are out there, but it would be nice if the state told us if it was good enough or not, so we didn't have to figure it out for ourselves every time something came down the pipe. So interestingly enough, one of these, looking at the executive orders in the federal government, the AI posture, federal government, their idea is hey, if we're going to compete with China, we have to be very open in terms of AI engagement. But of course, they're also saying you have to follow FERPA, you have to follow COPA, you have to follow all these laws to protect student privacy. So where does it fall between you want us to say anything goes with AI because we want to be out there at the cutting edge and we want to be competing with China, but at the same time you want to protect everybody's information and do all this stuff. So as school districts, we're sort of caught in between that space. And I don't know how much, when we're going to get guidance from PTAC on AI. As you know, it took them 30 years to give us guidance on what to do with a video. So how they're going to give us guidance with AI is, not to be expected anytime soon. So charter schools and homeschool, this is our legislature is friendly to these things. So we've already dealt with this. We have to make sure, we're working on this. The team's working on making sure that our homeschool students are going to have access to these tests. Since we provide these tests to our students for free, then we're going to provide it to the homeschool students for free. So we're just one other thing. We just got to figure out how we're going to pay for this and how we're going to do it, and how we're going to communicate it. But we're not planning on taking away the free test access for our students. So that means we're going to offer it to the homeschool community as well. And then the charter piece, and I think we're going to, I don't think we can unpack everything on charter right now. I think that's another exercise as we think about, there's a lot of things we got to clarify on the charter side, and that's a big goal for us, is to be more clear, more open, so the charters know exactly what to expect from us earlier in the game as these legal changes keep coming out and we're trying to navigate them, try our best to sort of get out in front of them and establish some clarity. But the big piece that happened this time around is the window of school districts, 10,000 FTE to 60,000 FTEs. If you have a Swiss waiver or you're a charter district, which we are, then during the term of your Swiss waiver periods, which I've got another, whatever 4 years we have on it, you can, once you deny 2 charter positions that are ultimately approved by the state, then you are deemed prima facie suspect under the law in terms of being a pro-charter authorizing district. So, and what will happen is you could have your Swiss waivers taken away, or for those that are charter districts, you can have those taken away for up to 3 years, I guess, on your next Swiss cycle, and then you'll have some opportunity, presumably, in the meantime, to prove that you actually are a innovative pro-charter authorizing school district in order to reduce your 3-day Swiss waiver piece. But you can imagine facing a window of saying, well, your Swiss waiver is only suspended for 6 months, but you have to do all the things that you were waived for these 6 months, move heaven and earth, and now you're back out. So any time period, with the Swiss waivers pulled would be a monumental ask for a school district to do. You'd want to hope that your denial happened earlier in your Swiss thing so you had a chance, and hopefully they would give you audience to make your case as to why you did what you did. But it is highly challenging. Yes?
So that's kind of provocative. The question I have is, okay, if you turn down 2, is there no attention paid to the reason it was turned down? Like, we've had some charter applications that were not fully baked. They were turned down and they were improved over time, and then they came back and they were approved. So the declination wasn't like a philosophical argument. It was, this hasn't been matured enough to be implemented immediately. So they're not looking at any of that, are they?
It's a great question. I mean, what we're trying to do is we're trying to align our evaluative process to the same things that the state is looking at, because we're going to sort of be judged by the state standards. At the same time, we have our own policy as to, we want this to be, the charter to be innovative in terms of offering something more than what we're offering. That particular component isn't clearly delineated in those state standards, but it is in our policy, and I think it's right for us to have that standard. But then if you push for that, you may find a disconnect. And you hope they look at it the same way you do in terms of all the other requirements. They may not. They may be more forgiving. They may say, this is great. You guys were too hard on this. And if they do that twice, then you're in that situation where you're going to be presumed to not be a pro-charter authorizer. And now you've got to make your case in order to obviate the Swiss suspension.
Okay, so that's the catch for it, is that if we decline it and they decline it, it's a non-issue.
Correct.
So if it's not well-baked, we would
You're hoping that
be
they
hopeful
view
that
it the
they
same.
will have the same standard. Okay, thank you.
Yes, Ms. Grabowski.
I had a similar question that and I think I know the answer, but I presume, because along those same lines, is there a requirement that what they submit to us for review, that what they submit to the state is the same as what we saw? Because I could see
Yeah,
someone submitting an application, improving it, and then submitting it to the state.
I can answer that.
Yeah.
Having gone through it, yes, you have to submit the same thing.
But when you went through it, but is that going to be the requirement moving forward? Because
I presume it will be, because it would be very unfair for it not to be.
Yeah, yes. Yes.
You
They're
can't, I
presented at
can't
the
say,
same time.
I presume it's not specified in the act that I know of that it has to be exactly the same. But I think it's presumed that it would be if we're going to be judged by our assessment of that same application. Yes.
But then we should probably just get rid of our policy that is asking charters to come with something that would be different, that would teach us how to do public school differently. And it's literally just to borrow the state. You want to open up a charter school, you've got a board, you've got finances, you get to open up a charter school. That's the way I looked at it, is that it's just you want to do it. If you've got do it. Where we've always wanted a charter to show us and prove to us they can do something better so that we might be able to take that innovation and spread it across. That's not how the state looks at it. The state just looks at it as, oh, you want to open a charter school? You've got funding, you've got a board, you've met you've dotted your I's and crossed your T's, you get to be a charter school.
Yeah, and I think from a big picture standpoint, what we see is a shift to getting away from front-end denials for whatever subjective reasons the board might have in their view, and say, get in on the front end, but then where the law has the teeth is on you got to meet those standards. You got to be the Lake Wobegon Charter School, right? You've got to be better than average. You've got to perform at this level, and if you don't, your existence is built on is contingent on performance. And I think that's been a challenge for us in the context of COVID and sort of all the things with the standards and the changing the standards and all these pieces. But I think the way the law is being put together now for school districts is you be favorable on the front end, and then not necessarily saying it, but it's like this thing is all about delivery and performance. If they deliver, they can continue to be, and if they don't in terms of performance, then there's nothing in the law that says you get to keep being there if you're not meeting those standards. So to me, that's the shift. And you can also see in this law, they have, when you approve the charter, now they're giving you $250,000 for the first 3 years. So they're incentivizing both with the carrot and the stick to say, you let them give it a shot. And I think you're right in terms of alignment. It is wise if we want to keep our Swiss waiver, it is wise for us to align our assessment to the same assessment that the state is going to apply.
Okay.
And they haven't changed the criteria that we would judge their contract on. We just, as a board, need to know that we might have to just say, this is a number you're supposed to hit, you didn't hit it, you're no longer a charter.
Well, the good news is the team, so under the leadership, we have developed for our last assessment of the charter that's coming before you, and that evaluative tool was really rooted in what the state was looking at. It was a very purposeful effort to let's just get right into what the state is doing as much as possible. And I think we have to continue to modify. If the state changes the way they're looking at, we want to be in lockstep, I think, from a strategic standpoint in terms of the state's approach on these assessments.
Ms. Hall and then Mr. Katchmar.
I had thought we were going to wait until you were through, but since we're opening it up now, I want to go back to the whole idea of the cell phone problem. And, I often think, what does GSBA do for us as a board? Besides us going to their conferences and all, what can we ask of them that would be helpful? And to me, this is something where we need to pressure them to come up with a statewide policy, because it absolutely makes no sense for every district in Georgia to have to go through this and try to figure out the best way to do things. Eventually, nature's going to make it happen anyway. It's going to be forced on the state to do it. So to me, let's ask our organization, we don't have a union, but that's the only thing we have, this GSBA, pressure the state to come up with things, not just for the phone, but anything else where they're saying the entire state must do this, must do that. Get busy and do something for us. So I'd like to know how the rest of you feel about it, but it's just not fair to take our staff time to do this and to take our time when we know eventually whatever Effingham County does, Chatham's going to have to do, Cobb is going to have to do. So let's get busy with it.
Mr. Katchmar.
I'll take fake local control and unfunded mandates for 1,000, Alex. I mean, on that point, that's just one of 10 billion issues, but I agree. I want to talk about the charter stuff, but my broader question in response to Ms. Hall's comments are, and you alluded to some of this, how many of these new initiatives can we wait to hear from the feds or the state for guidance versus we have to fumble around in the dark and then be told later, sorry, that's wrong. I'd much prefer to not do anything until the state or the feds say, here's the guidance, and then we look at their template or go by and then say, okay, or we adopt it versus wasting time as a board and our staff time trying to figure out what compliance looks like. So that's just a broader, like, philosophical approach. You're going to make us do this without guidance. Can we wait until the guidance comes? On the charter issue, there are kind of two things. Back to that discussion on we get pinged for being anti-charter if we deny two and the state allows them. We're going to have to be smarter about how we evaluate charters on the front end. If we're like, we don't think a charter focused on colors advances the ball, so we're going to deny it. That's a subjective analysis, and we're much more open to the state saying, no, that's a great idea. But if we deny it on lack of a facility plan, on a good financial plan, objective criteria that the state mandates we look at, I think it's going to be harder for the state to say, nah, we don't agree with your subjective analysis. So we're just going to have a smarter evaluation instrument. And even if we don't think a charter based solely on colors is great for this district, we also have problems with their financial plan and their facilities plan, et cetera. Let's include those objective measures that are based on state evaluation criteria, so we're a little more insulated on the front end. And also, we probably don't want to be the test case. Let some other district be the test case. And then that'll give us the go-by on how we deny charters on the front end if in fact that's what we want to do. The second issue is on existing charters and evaluating them and all that. I've been saying for years we need to update our contract with the charters, one, to avoid the lawsuit issues we've gotten in before, to make the terms much more charter or much more district friendly in terms of we're going to sit down with you in this window, we're going to define the formulas we're going to apply based on state guidance, obviously, not just some ad hoc decision we make, and you agree to that. And if you don't, then here's our contract, take it or leave it. But it's going to be, I want to insulate us from lawsuits as much as possible. And then we also need to build in terms that say when the state or the feds mandate changes in programming, in formulas, in requirements, we agree that those new terms will apply to you as well. And we will amend the charter contracts because the previous charter contracts we've done don't require them to stay current with a lot of the regulatory stuff that we have to stay current with. And we just need to be proactive about thinking about how the state is regulating us and applying that to the charters as well. So we have more flexibility in holding them accountable, but also in limiting their ability to just file lawsuits and get leverage, which takes a lot of staff time and board time as well.
Yeah, those are great points, and it's something that is a high-level concern for us in terms of freedom of contract as a party to these charters. We are a party to the charter, yet the state takes the position that we do not have authority to enter into a charter term agreement that's different than their standard form. And so there's another potential, legal challenge there to walk that road, or a political challenge to say this just isn't right. If we're truly a party to the contract, we should be able to reasonably come in and have some of the terms that can make it work for us because of what we've seen. But that is not what we're getting from the state when it comes to these charter agreements. So that's a big issue, and it's one of those things that I think is going to require larger collaboration or someone that's going down the road with whatever that lawsuit could be in terms of that. Because when you add in the mix of, you can't be denying for these reasons, or you're going to lose your status, I think the strategy from the state legislative standpoint is to say, hey, if you want flexibility, you play by our rules in a way on these things that we care about, which is our world of flexibility, which is the charter. So it's a really good challenge, and I think we need to continue that conversation, outside of, in terms of, what approaches we can really take there. But those are great points. One more thing I'll say is that it's a huge, heavy ask and heavy lift that also when there's a denial, 20 days you have to provide that basis for the denial. And it's not just tracking through all the different pieces of the evaluative tool and why the financial plan doesn't work or why the safety plan isn't sufficient. But you also have to go and say, these are why all the schools that could serve the students you would be serving are really good schools, and provide a report for all those schools. So we would have to have a report, of every school that's within the range of that charter school's catchment, which is usually district-wide for whatever age band that is, that would meet those requirements. And maybe you'd say, well, we should have that anyway. We should be able to defend what we're offering at every school and have that ready to go. We don't have that ready to go right now because that requirement hasn't really existed before. But if you walk into a charter denial, you will find yourself in that heavy lift of school-by-school reports, whatever that would look like.
So, a couple of comments. First of all, at the last GSBA conference, there was a session on cell phones, and it was, I think it was it Marietta schools? It was one school district that had a policy, and they were having they started their policy last year. So there are some examples that we can look at of policies and that have been enacted and the results and all of that. So I'll remember and distribute. Yeah. Was it?
There are nationwide ones.
Right. So number two, having been the one person that's ever gotten a state charter, state charters are very hard to get. State charters are actually harder to get than local charters. Most of the state charters, with the exception of Chatham County, are the schools that are approved as state charters are coming from school districts that habitually deny charter schools. They basically have a no charter school policy. So that's A. B, I'm a little uncomfortable having a focus on how you deny a charter school. Why that? Let's make sure that our denials are perfect. That's a little disturbing. Either we are a pro-charter school district or we're not. And if we're leading with, well, let's make sure that our denials are really good, I don't like that message going out. Yeah. Okay. Hoskins Brown, then Ms. Cashmore, Ms. Hall.
So I do have a reaction to your comment, but I was waiting to respond to one of the things that Mrs. Hall said, and that is that we can advocate for the things that we want to see GSBA be responsive to, and that's why we have a liaison who does a really, really good job. So I heard Mrs. Hall articulating this is what we want GSBA to know, and I saw our liaison's ears perk up, like, okay, yeah, So I think we have a way to convey that message throughout the year, and I feel confident in our representative to do that. On the denial or approval that is being built into this legislation, I think what is really positively balanced about it is what they're saying is if you want to keep being flexible, you have to be open to how other people are flexible. And I think that's actually very philosophically balanced. I like that idea. I think the reaction to rejections is, how do we make sure that there's fairness throughout the process and that our rejections are not misunderstood for being pro or anti-charter? So my reaction to one of the things you just said, the only thing I disagree with is I don't think we have to be pro or anti-charter. What I aim to be when I come to work is neutral. Give me the information, I'm going to assess it, I'm going to tell you what I think. I don't think we have to be pro or anti because that is an implicit bias in itself, because that would say that we would more positively review applications that maybe need a little work, or more negatively review applications that really don't need any more work. So I'm not going to aim to, I have worked to not let anyone think that I'm pro or anti-charter. And so I'm going to continue, from this seat doing that. But I do think that this conversation about avoiding the penalty of having our waivers taken away, is about making sure that we are not inappropriately penalized for a good and judicious decision versus, 5 votes saying, we don't like charter schools, so we're not going to approve it. We don't care how good your idea is. And I think the last thing I would add to that is some of the ideas that have come forward from charters have simply, I remember a couple of them being just straight illegal on their premise. Like we couldn't approve it because you're trying to do something that state and federal law prohibit. So you have a great design, you have terrific financial backers, you have a population of families that would want to do it, but we can't approve it because it's just illegal and that creates exposure for us.
Yeah, that's a unique one too, because the state was specifically permitted to offer a school like that. So what would happen if the law prohibited us from doing it, but the state could? There's nothing like that particularly baked in to the law. That would be an interesting scenario if it came up. So I want to honor everybody's time. It's a really good discussion. Yes,
Hang on, we have some more.
Yeah, so the only point I was making is if they're going to hold us to higher standards and punish us, we have denied charters in the past because there were 7 reasons, but the ones articulated were we didn't like the idea. All I'm saying is we need to articulate all of the grounds and check our boxes and document our decision much better so that when the state says, oh, wait a minute, we think you're being subjective, no, we're articulating all of our concerns. I'm not pro or anti. All I'm saying is we need to document our file much better on the front end because we know what is coming when they appeal to the state. That's all I'm saying.
yeah.
Ms. Hall?
Well, I've always felt that it was objective for us to say, come to us with ideas that we can implement on a broader scale to help all children. To me, that's an objective. That's not subject. That's pretty much, and I would hate to think that we'd have to leave that stance for some rule or regulation that needs following. Because to me, it makes sense. It's a reason to share our resources, and it builds the whole community. So
Yeah, and that's a great point, and I think that really has to happen relationally, and I know that's really where we're pushing as a district and leadership is let's really lean into this opportunity to have charters be this lab for, new developments and the learning, and that's really something that, Stacy and her team want to foster. I think we can put it in the, they can be there in the initial evaluation, but I think it's important for that evaluation to be aligned as much with the state standards to Board Member Bringman's point as possible, and that, to Sean's point, it just means you really have to do your homework. If you're going to do a denial, not that you're looking to do it, but realize that there is a lot of work. It needs to be clearly articulated, aligned with state standards, and then also that we have to, give our little report on every single school, which is, oh, by the way, due in 20 days from the decision. So
Yeah.
it just means it's a really heavy lift, and you have to be prepared. If you're going to do it, you have to be ready and prepared to implement the denial.
But Dr. Watts, when we hear something good, when we find we have a charter school that's come up with something that might help all of us, we have to make sure that we attempt to implement it. You know, I've heard several comments, most recently from Dr. Wall at Oglethorpe, of ideas like his idea to have all of his teachers gifted certified. To me, that's that's quality, baking in some quality. So we've got to show that when we do hear something good, we are acting on it. So that's the other side of it.
Well, let me keep moving here. We're nearing the end of the slideshow, so that's good. In terms of, these are the things that got sent HR's way. So since we do take out, Social Security, we provide the Social Security, assistance, we get to tell our employees that we're doing this for them, which to me makes our job more attractive because we're doing both TRS and Social Security. But the law requires us to give notice at certain junctures. So that's not something that requires a policy. That's just going to be implemented by HR. Our leave policy, we're probably going to have to take account of this bone marrow and organ transplant paid leave provision that was added, 7 days for bone marrow, 30 days for organ. And then the death benefit for under workers' comp, that was doubled. It had been left where it was for quite some time. So that's just another cost of self-insuring workers' comp. There may be some other pieces there. I've heard some discussion and maybe some other shoes that are dropping with that workers' comp that I've not quite wrapped my brain around, but I thought that was the main point of it. So there may be something else there. Campaign finance, the slide is there for you. I don't want to spend a lot of time. It kind of explains itself. Miscellaneous, we have Early Literacy, Dyslexia Act. It's really trying to get into that whole science of reading piece and saying you're not going to use the 3 Qs system. So that's really what that one's all about. At the same time, we got to make sure that we are giving our staff the flexibility. If we have students with special needs, they don't want to feel that their hands are tied with methods that could work. So we're just going to kind of navigate that to make sure people know that these are things we can do, but the 3 Qing is officially anathema from a legislative standpoint. So if something is going to help a child based on their specific needs, we just have to kind of look at that through the lens that one is it's going to be frowned upon. Doesn't mean we can't design something that will fit the particular needs of a child, but folks are working on that. That's not going to require any action from the board. There's some things for Dr. Lewis's team. They're the top state for Talent Act dual achievement program. That's not going to, I don't think it's going to take a policy, but sometimes with those, there's language changes that come up, with CTA's things. So there may be some language change that comes up before you. I'm not sure, but I wouldn't think anything substantive that would be a big area for that. The construction limits going up, we've already dealt with that. The policy's already in place, so you've checked that box. The playground piece, there's going to be more oversight in terms of playgrounds. There's more money, more oversight. That's something that capital projects is going to be working on. And there we go. So that's all there is.
Mr. Grabowski.
Thank you. It was a fire hose, but it was great, so thanks. 2 questions. Going back to the state Supreme Court case that you were talking about.
Wilson case.
Yes. So, and if I understood it correctly, there's this gray area about potentially increasing our exposure and reducing our sovereign immunity potentially. And that's something, so my question is, this past year, the governor's top priority was tort reform to eliminate frivolous lawsuits. But if we're now on this flip side of potentially facing additional lawsuits, is there any thought about that at the legislative level that we might be inadvertently going against the tort reform that was just adopted this year?
Right. So this is coming from the Court of Appeals, and it's coming from interpreting what a ministerial duty is, which really comes down to, do you have to do it without thinking about it or not? If that's the way you look at it, but then there's so many things that you prioritize. You may not do it because you've got to do other things, so this whole black and white idea that everything you have to do, if you don't do it within a certain time, you've violated a ministerial duty. We see these laws. We have to decide what we're going to do. We do it all. We work through these situations over time. I think I do not see a legal change on that official immunity standard that's going to come from the legislature anytime soon. It may. It's always been a situation where the Supreme Court, oftentimes the Supreme Court clarifies that we have robust sovereign immunity and official immunity eventually, and it's standing up there. And the Court of Appeals, oftentimes some Court of Appeals opinions seems to be pushing it out. And then there's a counterbalance from the Supreme Court of Georgia. That's probably where that would most likely come from. Okay. From a legislative standpoint, whenever we see these laws like EpiPens or diabetes treatment, I mean, all these different things, lots of times they'll have a carve out and they'll say you can't be liable for doing these things. And of course, Mr. Holliday's point is often like, you don't need to say it. We've got sovereign immunity. Why do we keep putting these carve-outs? I mean, there's an argument if you keep putting sovereign immunity carve-outs in every piece of legislation, you're almost inferring that the sovereign immunity isn't always there everywhere. Right. And so is that really a good thing to keep putting those carve-outs in there, because it changes the perception of the ubiquity, the umbrella of sovereign immunity. Right. So I don't really know if we've got an easy legislative fix on that. I think we are largely at the mercy of the Supreme Court of Georgia to really think about the implications of how many people could get sued individually if this case is expanded to the place where the plaintiff's bar would like to see it, that it would make it very troublesome for a lot of people to say, I do not want to get involved in this kind of work if I'm going to be facing lawsuits where people are suing me individually, even if it's insured by the district ultimately. I think it's concerning to open the proverbial floodgates in that. And I think I'm hoping that the Supreme Court of Georgia will take a hard look at that and really see, what the implications of a broad expansion of the ministerial duty would be to the people that are doing the day-to-day work of the school district.
Yeah. Okay. And then my second question is switching gears a little bit to the technology, and it's really, I think, more for Dr. Watts and her team. Knowing that this is going to be required at the middle of our school year, and that we already have a policy that allows each school to make the decision on a case-by-case basis, are we doing anything to encourage at least our elementary, middle, and K-8 schools to go ahead and implement a policy at the beginning of the year, and then providing them because to me, it's so much easier to go ahead and do it day one than to try and shift gears. And it might be there needs to be some messaging that goes with that of this will be implemented. We don't have the policy yet, but it will be implemented because of state law by January 1st, whatever that date is. And perhaps there's a way that we can give some guidance to schools to encourage them to go ahead and do that under our existing policy?
Yeah. So just from a school leader standpoint, I think to do that now would be impossible because it requires a tremendous amount of change management and training and support. My vision for this, and hopefully it aligns with the deadline, is that we would implement the policy by mid-year, but we would operationalize it in the upcoming school year.
Okay.
So it would give us time to support schools with consistency, because what I want to avoid is the same thing that you all are talking about from a county by county.
Right.
Is a school by school by school by school implementation, and then we have to go back and adjust for that. So I think the policy has to be written first, and then we work on the operationalizing of that plan and roll it out for next year so that there's adequate time to communicate with families, with teachers, if there are supplies that have to be purchased to house devices, we have the rollout time to do that.
And that makes absolute sense. Under the state law, do we have that leeway to have the policy in place and not operationalize it until later in the year?
You're talking now about the cell phone? Yeah, I mean, that's the way to me, that's the
Okay.
only sensible way to read it.
Okay.
I would like it if it was a little more clear as written, but I think from a common sense standpoint, it has to be what the statute means, in my
Okay.
view.
I mean, all that totally makes sense, but we also know that things don't always make sense that come to us. I just think that making sure, and I think most people are aware that this probably is coming. But if there's a way that we can just provide information to our schools to maybe outlining what your plan is of this is what we see moving forward, because my sense is if parents know that they're not going to be allowed, in 6 months to a year, it sometimes makes it easier for the parent to go ahead and say, you know what, let's just go ahead and do it now. So if we can.
I definitely think there is some preliminary information that we can begin sharing, yes.
Dr. Howard Hall.
Yes, good morning. I know that most times, anytime the state typically do not give us guidance, but they give us deadlines. So when does a district find that their policy is ineffective? Is it typically when there's a lawsuit?
Well, I do think that there is a good bit of guidance that's on the way, both in the cyberbullying law and in the cell phone piece and in the record sharing. The challenge to me is the timing of the guidance. To Mr. Katchmar's point, they're saying get this done, and we're going to get you the guidance. That it doesn't make sense for us to be required to do things before guidance is issued, and in many cases, guidance doesn't get issued on schedule. At least that's been my experience over the past decade or so. Is that lots of times it doesn't quite get out on schedule. Certainly, in the federal side, just legendarily so in terms of lots of times, very extended delays on federal guidance documents. But the state tends to meet its deadlines. Sometimes they'll meet them on the day of the deadline. So I would expect that we will be getting that guidance, but it is troublesome. But then I think when we get it, then we have to pivot to what the guidance is, and that just means we might have to revisit some of the things we've done if we're required to implement pre-guidance.
Anyone else? Yes, I'm sorry, Dr. Johnson.
Oh, no problem. I just wanted to say in general that this is extraordinarily helpful, and I know it's giving this information through a fire hose, but there was a similar session at GSBA this year, a whole day-long policy workshop where they went through everything that was happening locally and federally. It's recorded. It's in is it Hoover, how you say that app? But it's in the Hoover app, and that, along with this, is extraordinarily helpful because people are asking in general, people are stopping you in the grocery store and saying, hey, how is what's happening affecting local education? And it's extremely difficult to move through all of these documents in a timely fashion. So the fact that I can, last month, the National Newspaper Publishers Association had their conference in the city, and they wanted someone to talk about influences on education. So I was able to draw from what GSPA created. The same for you. I'll be listening to the podcast. I often need something to listen to while I'm gardening and weeding, and it'll help reinforce all of this information because we need to know and we need to be able to react. When documents come for our approval, we have to know how what we're going to decide in this is going to land in the larger landscape. So thank you for the work that you've done to give us this instruction.
Thank you very much. And yeah, honestly, it's kind of fun as a sort of nerdy, for the nerd side of me, it's like this is kind of fun because it's quite interesting and challenging and there's a lot going on. It's also exhausting and I can tell, it's just overwhelming for staff. So fortunately I have a little bit of nerd in me, so it kind of motivates me, but yeah. But thank you.
Thank you, Mr. Dennison. Thank you very much. Okay. I will accept a motion to go into executive to discuss real estate, personnel, safety. Real estate, we did. We did real estate, yes. Okay. Moved and seconded. All in favor? Aye. Aye. Let's go.